Hey, welcome back. Carl Rominger here. Hey, this is hour 2. If you're just joining us, we're going to be on every Saturday from 1 to 3 here on WHP 580. This is the first week we're doing that. But if you're tuning in at the normal time and you didn't get the word yet, it's going to be from 1 to 3 from now on. And next week, if you don't have anything to do, between 1 and 3, we're going to be live broadcasting from 1000 North Prince Street in Lancaster. So come on down, enjoy the atmosphere, ask a question in person if you want. Just listen to the show, meet and greet everybody, and then we're going to hang out till about 4 o'clock after the show just to, see what's going on. And that's open to the public. There's going to be food and prizes. And also, don't forget, we'll be giving away some Rillo's gift certificates. If you like a good Italian meal, Rillo's in Carlisle is a good place to go. Kind of one of my favorites. I actually ate there last night, so I had a nice steak and a nice ricotta cheesecake that's really good. So I had dinner there last night. We're going to give away a few gift certificates for them. And let's see who's next. George, you're on the air.
Was it George?
Yep, it's you, George.
Hi, Carl. How you doing there? Great to talk to you. And your insights over the years are excellent. Listen, when you talk to Bob often. My situation is somewhat complicated and convoluted. I'll try and make it as brief as possible. I'm a small businessman, sole proprietor. I have 2 to 4 helpers that help me throughout the year. I 1099 them throughout the year, or at the end of the year, we go into clients' homes and do work. Back in the end of the year, the end of last year, one of my clients called me, had a piece of property missing. I suspected one of the individuals. I just as a matter of policy, reimbursed the client for that piece of property that was missing and terminated the services of that individual. Shortly thereafter, I received a call from another client. Right after that, received a call from another client, numerous items missing from their home. Police department on the West Shore very actively and aggressively investigated it and ended up interviewing the suspect, with my help and involvement, and got the person to admit to the theft.
Okay.
And then she also applied for unemployment, which under what I consider an independent contractor status, she received. They denied it under that status, saying that it wasn't legit. But I also brought up the theft issue. At that time, charges hadn't been filed. She denied any theft to them, and she did receive unemployment compensation, which I then appealed. I won the appeal hearing. She did not show up for the appeal. She has now since reappealed, saying that she can't understand I owe her the money, so I should pay her the money. In the meantime, I received a packet of information from the Pennsylvania Human Relations Commission. She charged me with sexual harassment, making a substantial number of salacious claims, which are totally false and without merit, absolutely never occurred, and I'm in the process of handling that. I did consult with an old friend / acquaintance attorney, very well-known gentleman in this area. Matter of fact, he said that if it ever would go that far, he knows acquainted and friendly with 6 of the 8 people on the HRC. Anyhow, the end result, I think I've got a pretty good handle on the unemployment issue. I think it will ultimately be denied completely, and she'll exhaust her in any appeals process. The theft issues, another client has now come forward, and another department is investigating that, and I suspect the charges, I shouldn't suspect, charges are definitely going to be filed in that case also. So we'll have 2. Incidentally, this ex-helper did not show up for the preliminary hearing. A bench warrant was issued from the DJ's office through the DA's office, and part of my question is that there seemed to be some mix-up between the DA's office, Sheriff's Department, the APO, I think, APOC system, as to whether it's an active warrant. It is. I've been assured of that. And if this person has ever come across, will she be picked up? And then the other point of my question is, under the Human Relations Commission scenario, the attorney that I consulted with basically just did it on a consultation basis, felt it would be a waste of my resources to bring him to the informal conference, that I should just be able to explain the whole thing in a a brief letter, which I did, and then I've also since been in contact. The lady from the investigator from the hr2 has looked at the whole thing, said you didn't send me enough information. I mean, I can't send information that I don't have. I'm not a big company. I don't have big employee files.
Right.
No harassment ever existed or ever took place, so I never had any need to investigate anything. She's bringing it against me. I've since been on, I think, a good conversational and discussion term with this investigator. The hearing is scheduled for the 20th of this month. And I've since basically sent 3 sets of information letters, trying to give her all the information, details, and everything. My main point of the question is, first off, regarding the arrest warrant scenario, and then number 2 is, should I have an attorney at that conference?
Well, let me just tell you my thoughts on the matter. First of all, yeah, they'll arrest her, pick her up on a warrant if law enforcement encounters her. So she will get arrested sooner or later. Number 2, and this is probably more salient, I would usually recommend you take somebody with you to that informal conference, only because it's your first time through. You know, we've sat through those with clients before. We know what the investigators are looking for. We can also kind of talk on your behalf.
Now, see, that the letter that they sent said that the attorney can't really say anything.
Yeah,
am I incorrect in that?
We let me explain it this way. I understand that, and usually we don't go in there and just give the spiel. But I guess I explain it like this: when they ask you questions, you answer them, but you get to look at me and say, what should I say?
Okay, I got it.
So, yeah, technically I don't speak, you do, but there's the informal portion of that informal meeting where the investigator talks to you and talks to me, and I can I've said before, here's what I'm thinking. Now, I remember being on the opposite side of one of these, by the way, where the employer made some crazy comment, which he thought was just kind of funny, but he said something along the lines of, like, well, I talk to all the girls that way or something like that.
Okay.
And, I could see the investigator's eyes go, like, he shouldn't use the term girls.
Right. Mm-hmm.
I think she was right on him, like, you don't call them women, And I was thinking, like, oh, poor guy, nobody gave him the briefing that, you gotta remember that these people are, especially if you think that you're sensitive, these people are sensitivity training times 10. You got to be very mindful of what you're saying in there. So I usually recommend you take a lawyer along. Costs you a few $100, $300 to $400, probably to have a lawyer sit in that meeting. But hopefully that ends it. What you really want to do is get them at a point where you're saying she's not cooperating in the investigation, and if she shows up, that's when you get her arrested.
Yeah, well, I believe me, that's on the plate. But what if she doesn't show up? Which I really don't think she's going to. She is just doing this to try to extort, a legal way to extort, to try to an attempt to make it a legal way to extort money from me.
Well, good news is if she doesn't show up, then at some point they're going to say she abandoned her claim. And that's the other thing that I think as a lawyer involved in the case I would be pushing for and working on, is basically saying, hey, listen, if the other side's not going to bother to show up, then there's nothing to do here. Let's just move on. Ask him if he did anything. He's going to say no, and that's the end of the investigation.
Okay. I was a little disappointed in the consult with the attorney that I did. I think his specialty is criminal. I don't believe he's ever handled one of these. Because my understanding initially was, when I sent this first letter explaining that the basis of the theft and everything, that it was retaliation on her part, not against me. My termination of her was not any type of retaliation
against her, right?
Exactly. That he thought that would be enough, and obviously, in my conversations with the investigator, that wasn't nearly enough.
And here's what I would tell that attorney. I would say, here's the problem. They're an investigator, and if somebody just sends a letter that says it ain't true, that's usually not what they're looking for. What they want to do is kind of look at the whole situation and see, have you had these kinds of complaints before? If you have, how do you handle them? What's your process? What's your procedure? So they get a little mired down in a lot of detail.
They do, yeah.
That is more encompassing than the specific incident itself. And then fortunately, like any good investigator, frankly, they can't just take you at your word when you say it didn't happen. They got to do a little more investigation than that. I got to go to break, brother, so I got to let you go.
You've done excellent. Thank you very much. Appreciate your advice.
Thank you. 540-0580. See you after the break. Hey, welcome back. Carl Rominger here talking about everything legal. 540-0580. Don't forget, we're going to be live from Lancaster next week. Go ahead and give us a call or a holler if you want to come, but you don't have to. Just show up if you want to, too. We're open to the public. We're going to do it from 1 to 3, 1000 North Prince Street, and we're going to broadcast a show live so you can ask your question in person. Scott.
Thank you for taking my call. My wife and I are talking about a very friendly, uncontested divorce. The problem is, last week in my office, I discovered that I never filed my marriage certificate. The president judge married us just last year, said, don't forget to take it to the registrar's office. And I couldn't take it in, and then I forgot, and I've already been to the registrar's office, and they said, if you want to get married, because we don't think you are, you have to get another marriage certificate, get married, and file it. What should I be expecting when I speak to my attorney? Because they have no record of my marriage in my county in Pennsylvania.
Interesting. Well, I'm not certain, but my thought on the matter is, the judge has the power to marry you. And I would think that the registration of the marriage certificate is pro forma, meaning that, well, it's, something that needs to be done. It's not really it's not the registration of the marriage certificate that creates the marriage. It's the judge's declaration that you're married.
Okay.
So it kind of reminds me of a court order that's entered but then not docketed. And, of course, that creates all kinds of problems because the next question is, when did it take effect, when it was ordered or when it was docketed? And I would think that a court order that's not docketed isn't of record, so it's not really binding, but it still exists. I don't know the answer. Okay. My thought on the matter would be is that you're probably still married. Now, do you guys want to be married?
We're seriously discussing divorce just because we don't get along.
Right.
But we're very friendly with each other.
So that creates the problem, which is, here's the answer. I think you don't have to attach a marriage certificate to a divorce decree, okay?
Okay.
In other words, when we file divorce, we just allege that the parties were married on or about blank date, and here's where it happened, and we don't have to prove that marriage. So it would seem to me that I could, in good faith, file a divorce that says that you were married on at such and such a date at such and such a place, because you were. Now, nobody recorded the certificate. But what difference does that make? So if you are married, the divorce will essentially unmarry you. And if you aren't married, then the divorce is a nullity anyhow. But it caps it just in case somebody were to later say you were married.
All right. Okay.
That's my thought. That's my quick and easy solution. I want to still do a little research on it.
Well, thank you very much. I appreciate your time.
All right, Scott.
Goodbye.
Yeah, that problem seems like it probably fixes itself. Phil, you've been waiting very patiently. 540-0580. What's your question, Phil?
Hey, I've got a picture of someone in the middle of road rage. It's pretty funny, and I want to post it on the internet, but I don't want to get sued for taking pictures without people's permission. Is that legal?
If a person's in public doing something, they don't have a privacy right in it. If you use it for commercial gain, somehow you make money off of it, you may be appropriating their image for gain, and then that would be a separate question. But no, I think you can go out and just take photographs of people walking around and put them on the internet, as long as you're not bring put a bad light to them on something that they did privately. So the fact that the guy's acting out in public, I think you could post that. That's a thumbnail sketch.
Okay, because I was going to do that, but my wife said don't do it because of the one lady who was suing the mall because she fell in a fountain and stuff, and she was suing the mall because they didn't have permission to take her. I don't remember the whole story.
Yeah, that was the security cameras from the mall, and I think she was thinking about suing them, saying that they invaded her privacy, put her in a bad light. But I don't know if that one went anywhere or not. Because to me, it seemed like the only problem with that one was, again, were you doing it for gain or not? And if you're just doing it for, something in giggles, then I'm not certain that that's a problem. Now, if you want to play the safe side, don't use it.
All right. All right, hey, thanks. Love the show.
All right, man. Thanks.
Bye.
Yeah, I don't know. That's one you'd really have to think through. I guess I'd be most concerned is if you're using it to generate a million YouTube hits. But then you got websites like rotten.com, I mean, where they put up, autopsy photos and all kinds of crazy things. And I actually had a case years ago. Some women show up in my office and say that their father's on this website as one of the deceased pictures from an accident he was in. And, I was able to prove that it was an autopsy photo or something that a mortician had stolen or something. And we sued them, and they were kind enough to take it down because it turns out they didn't really want to be putting up stuff that belonged to other people or that they didn't have permission to use. So I thought that was pretty interesting. But, yeah, you can actually put up images of other people's stuff or cars or person that's in public because there's no expectation of privacy. The thing you run into is when you make money with it. So there was a guy who was the model on the Taster's Choice coffee who discovered that they've been using his picture all those years on there and sued him and got a lot of money because they were using his image to make money. The fact that they were just using his image in and of itself wasn't the problem. Stan, you're on the air.
Hi, Carl. A relative of mine has a trampoline in the backyard. And my question for you is, would they have any civil liability if any of the neighborhood kids got hurt on that trampoline?
Yeah, I would think so. I would think so. Now, here's the answer. The long answer is, I mean, if the trampoline is just accessible to the public, it sounds like an attractive nuisance. Kids are going to want to jump on it, etc. So if they're controlling access to it, then you would want to make sure that the other parents and kids knew, that it's an inherently dangerous thing and there may be an assumption of the risk. But if they own their house, they're going to have homeowners insurance, which will cover them for any acts of negligence involving the trampoline.
Oh, okay. I didn't think about that. Do you see many civil cases associated with injuries resulting from trampolines?
You know what? I haven't, actually. It's funny you say that because I just think back through my head. I'm like, I do car accident work, wrongful death, those sorts of things all the time. We get a lot of dog bite calls, but I can't think of anybody ever calling about a trampoline. When you think about it, it would be one of those things that you would, and I've had pool cases too where people get hurt or drown in a pool.
Yeah.
But I've never had a trampoline call, so maybe they're safer than we think. I have a feeling, this is my thought on the matter, I have a feeling that most people look at a trampoline and go, ooh, boy, you could get hurt on that.
Yes.
And they're a little more careful about it than they are things like pools, which people just sort of take for granted, but are extremely dangerous.
Yeah. Okay. Well, thank you very much for your information.
All right, thank you.
Bye now.
540-0580. Susanna.
Hello. This is kind of a complicated situation.
Okay.
I don't live in Pennsylvania, so I live in Maryland, and the crime actually happened in Delaware. So I don't know whether you would have any advice to give on this situation or not, but actually I have two questions too. But to begin with, I was raped 11 years ago by 3 men.
Okay.
I was knocked out and didn't remember what had happened. Also, I was a virgin at the time, so when I woke up the next day, I felt like I might have had sex with someone, but I wasn't sure because I'd never had sex.
Mm-hmm.
And so I didn't go and get any tests done, and I didn't remember because of the drugs that were used on me what had happened. But I know that the 3 men who were involved when my memory did come back, which was a little over a year later, that all 3 of the men involved crossed state lines in order to commit the crime, and one of them crossed international lines. It was a revenge action.
Okay.
Not just it was set up in advance. And I went to the police at the time, and I reported it, and they didn't investigate the case, and a couple of things that I had brought to them that I remembered the rapist having touched to be fingerprinted weren't fingerprinted. They were just discarded. My report was taken out of the police file and disappeared. And I don't know. I just want to find out. And also, I've been the people in question have been having me stalked and harassed the whole time since that 11 years ago, including stealing and killing my pets. And
well, here my thought on the matter is you're probably going to want to talk with your local law enforcement about that. But there's,
Well, I have spoken to the local law enforcement here, and I think they're keeping an eye on the apartment area where I live, but there really isn't a whole lot that they can do about it because it didn't happen in their state.
Right.
And, they don't have any evidence, and unfortunately I'm on Social Security disability. I don't have the money to hire somebody to.
Yeah, and the only thing I can tell you is, I mean, the answer is it happened a long time ago, so it's probably outside the statute of limitations for a civil suit. If you can't get the prosecutorial authorities to go forward with anything, then it's probably not anything that you can act on. Hey, I'm at the bottom of the hour, so I have to let you go. 540-0580. We'll be back after the break. Hey, welcome back. Carl Rominger here answering your legal questions, 540-0580. Take a few callers here in a second. I got to talk about a few things. First of all, Kaylee Anthony's verdict. Let's forget about the verdict for a minute. The idiots of the world are already proposing a new law. And why do I say that? I say that because the new law would make it a felony for the guardians to fail to report the death or disappearance of a child. And then in some other state, they're going to make it a misdemeanor. Well, guess what? If you killed your kid, I think the last of your worries is to report the death or the disappearance of your kid, right? So let's see. I could go to jail for life or maybe get the death penalty, but I also might get a felony if I don't report it right away, so that it'd make it easier for the investigators to find the body or the kid and get cracking on the death penalty case against me. I think I'll phone in the disappearance of my child immediately so I can avoid that felony charge and get the death penalty. I can't believe that the law is what it is. It makes no sense to me whatsoever why they would have Casey Anthony's case creating a whole new law. Makes no sense. So again, the idea would be, yes, I'm going to call the police, get in trouble, and rat myself out to avoid a felony charge when it's going to be putting me in hot water for the death penalty. Makes no sense whatsoever, and I would strongly urge the legislators of the world to not pass another feel-good bill that makes no difference whatsoever. And then, by the way, they wanted to make it an hour if the kid's been missing more than an hour, and then somebody else pointed out that means that every time somebody can't find a little kid for more than 15 seconds, there's going to be a report to the police, which is just going to flood them like crazy, which makes no sense. Who's next? Mike, you're on the air.
Hi, Carl. Thanks for taking my call.
Hey, no problem.
I had a quick question. I had the guardian ad litem from Perry County, the guardian ad litem of my son, give me a call at work, and she said that the defendant, my ex, had taken a gun, left the house, threatened to kill herself, kill me, and kill the child. She said the judge was notified, the police in the area, and Pennsylvania State Police in Perry County were notified. But then they found, or she came home that afternoon, and I'm not sure where she was. She had left the house with the child. The defendant had come home, and the court never prosecuted the terroristic threats towards me. The guardian ad litem called me at work. I run a school. We had to shut down the school. There's a daycare there. We had to secure all the kids. There's a lot that went on that day that was, pretty tense for some time until we were notified that the defendant had actually showed up at home. Her mom had called me and said that she was safe, that our son was safe. And my question is, why would a guardian ad litem have the right, or the judge have the right, just to let that slide in, Pennsylvania here, Perry County, just to say that that's never happened, and not pursue it and have her investigated, the child put into protective custody until the investigation was complete to see if she was stable? And I talked to the DA. in Perry County. He told me to call the state police and file charges myself. But my father's a state trooper, and he said it happened over a year ago, so they're just not going to do anything about it.
Yeah, if it was over a year ago, there's probably not anything that's going to happen about it. I mean, you can certainly complain and see. But yeah, at that time, somebody should have notified the police, and they should have investigated it. I can't imagine why they didn't.
I can't imagine it either.
But I think the district attorney's advice is sound. At least make the police report.
Okay.
All right?
All right, I appreciate your time.
All right, no problem. At least they notified you. I mean, I'll at least give them credit for that, huh? Douglas, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580. What's going on, brother?
Hey, Carl. Carl?
Yeah, I'm here.
This is Douglas. Hey, that hailstorm that we had, where it blew all the trees and damaged the houses. I had damage to my house. From the hail damage to my siding, I could see that the builder didn't put any building wrap around the building. That's all exposed wood all the way around the house. The house is 15 years old. And I was wondering if I have any civil legal action to go after the builder for that.
You might, and I'm just trying to remember what the statute of repose is on construction defects. Statute of repose is basically how long you have to wait to go after somebody. In other words, even if you don't discover something right away, the statute of repose, and here I pull it up right here, says a civil action or proceeding brought against any person lawfully performing or furnishing design, plan, supervision, or observation, or construction of any improvement to real property must be commenced within 12 years after completion of the construction of such improvement. So it looks like there's a 12-year statute of repose, meaning if you don't discover it within 12 years, then you probably don't have a lawsuit.
Okay. All right.
That said, I'm giving you the thumbnail. I would actually want to do a little more research on it. Now, the guy in my office, Steve, he was lobbyist for the modular home industry for years before he came to us and got into the business of full-time law practice. So he knows more about building codes and contractor disputes than anybody I know. So you might want to just call in the office and ask for Steve. He might be able to give you a better answer.
All right, Carl, I'll do that. Thank you.
All right, man.
Bye.
Yeah, that statute of repose. Here's the theory. The theory is if enough time's gone by before you realize you were harmed, then you couldn't have been that harmed. And therefore, what we're going to do is give the person who did the work or the original service a free pass. And it's sort of trading off the rights of you to be whole versus their right to not have to worry about stuff they did 100 years ago either. And that's the concept of a statute of repose. Lois, you're on the air.
Yes, my husband and I had wills prepared about 12 years ago by an attorney.
Okay.
And we would like to do a codicil to those wills.
Mm-hmm.
Now, can we do them ourselves, or should they be done by the attorney?
You can certainly do them yourself. Now, here's what I'm going to suggest to you, though. Why do a codicil instead of a new will? And the answer is, in the old days when reproduction and paper and formalities of a will were difficult to do, they were hand-typed, generally a codicil was a good way to modify the will. Mm-hmm. These days with modern word processors, most of the time we just redo the whole will as opposed to doing a codicil.
Okay.
If that makes sense. Because here's what happens. Here's the other theory, right? If you have a will and you have a codicil, maybe somebody finds the will but they lose the codicil.
Yeah, true.
And that's why we like doing a whole new will. That just prevents that.
Okay. Makes sense.
And Lois, if you go to weekendappointment.com, you can sign up for our free will program, and you and your husband could come meet me and get a free will, no charge.
Okay, and what is that?
It's weekendappointment.com.
Weekendappointment.com.
Yep.
Okay, thank you very much.
All right, thank you.
Mm-hmm.
540-0580. Cindy, what do you want to know about grandparent rights?
Well, Carl, it's a complicated story. I have a daughter who was married and had a daughter, and subsequently got divorced, and she had joint custody. She turned around and got pregnant to an old boyfriend who had gone to prison for, among other things, statutory rape.
Mm-hmm.
So she had the child, another girl, and was moving on and actually met a very nice guy. And while she was, well, what she thought, and when she was out of the house one day, he abused the child, and he didn't sexually abuse her, but he, ripped her vagina. She was taken to the hospital, and of course, Children and Youth came and took her immediately. And my daughter was questioned and found to be innocent, and took a lie detector and was innocent. It took a year for the police to finally charge him, but he did no jail time. But the thing is, both the boyfriend who was in jail got out of jail, and they gave the child to his parents, and so my daughter has no financial means to hire an attorney to go to court to get her daughters back. The father who was in jail, who now has the child in his possession, there are no legal papers regarding custody between the two of them. My question to you is, as a grandparent, it's absolutely killing me that I cannot see my two granddaughters, and I'd like to know what I could do about it, if anything.
Well, grandparents have automatic standing to bring custody actions in Pennsylvania, okay? So first of all, you have standing to get involved in a custody action. The question then has to do with the fitness of the parents in the situation, and based on everything you're telling me, there may be grounds to question that. And so you may have a leg in the door, so to speak. Now, some grandparents' cases are stronger than others. Sometimes I have a grandparent who raised the kid. Now, let me ask this. Did either of the children ever live with you?
Not for an extended period of time, no.
Okay. That takes you out from underneath the Grandparents Visitation Act, but it doesn't mean that you still can't seek custody as a third party where it would be in the best interest of the children. So my advice to you would be to sit down with someone who does family law. My office has it. We have a few lawyers that do, and pursue a custody action, or at least sit down and go through some more detail. But I think you would be able to get your foot in the door. And sometimes it's not as big a fight as you anticipate. Sometimes we can get your foot in the door, and the other side, rather than pay to fight you, goes, all right, what do you want? And then once you get in the door with a court order, then you're in for good.
All right. Even though one child's in York County, the other child is in Adams County.
Yeah, so you got two different cases. I mean, you're going to have to potentially bring it in two different counties.
Right.
Romingerlaw.com is our website. If you want to get a hold of Rob or myself in the office, I'd be happy to help you.
Okay, I will call you next week.
All right.
Thank you.
Thank you. Yeah, it's tough when you're a grandparent because you don't have the same rights as that. In fact, I was just writing a brief on this the other day, and the law says there's a presumption that the parent gets that gives them a strong leg up on any third party, including a grandparent. But it's a presumption that can fade if the best interests of the child weigh out in favor of the grandparent. And so, for instance, if mom's smoking crack cocaine, grandma and grandpa are probably going to win, assuming there's no father involved. On the other hand, if grandma and grandpa are super great and wonderful and the kids really love them and et cetera, but mom's still pretty swell too, then grandparents are still never going to win. But if they can get under the Visitation Act, then they can still force visitation even without the parents' consent. So a lot going on in those custody cases. I know Shane's banging on the window, so I got to go to break. 540-0580. See you after the break. Hey, welcome back. Just answering your legal questions here from 1 to 3 every Saturday on WHP 580. Chris just popped up on my Facebook with, I can't call in, but if you get a chance to explain why jurors in PA cannot take notes during a trial. Short answer is they used to be prohibited from taking notes entirely. We have a new rule in place. If the trial is going to go more than 2 days, then we can get note-taking. So we do have note-taking in Pennsylvania now, but only on trials that are expected to go more than 2 days. And we now allow written jury instructions to go out with the jury on the actual offenses. So Pennsylvania has come out of the dark ages and up to what almost every other jurisdiction, except I think one now, is doing. We were like the second to last. So you could be in a federal courthouse in Harrisburg, and you would get note taking and written jury instructions, and then you could go across the street to the Dauphin County Courthouse and be told that you weren't allowed to have a written instruction because it might somehow unduly influence. Now, and there is something to be said for that. Back in the old days when 10% of the population was literate, the guy who could read could just sort of lie back there in the jury room, right? Well, it says it right here. This is what it says. And they gave him an unfair advantage. Notice I say him because there was no she's in the jury room in those days either. But as the literacy rate has come up, we presume that most jurors can read. I know, har, not those ones in Florida, right? But anyhow, we assume that everybody's on par and that a written document's not going to unfairly advantage one of the jurors anymore, and that's part of the reason why we didn't historically allow note-taking or written jury instructions. George, you're on WHP. What's going on?
Yes, Carl.
Yes.
I had a deck put on about 5 years ago, and it cost about $2,500 because it was just the decking part of it, and now it's rotting. And I contacted the limited warranty people that are the wood, and they're offering to pay for just the replacement of the decking boards because of the limited warranty, but it's going to cost me a fortune to get it ripped off and to have the boards replaced, even if they paid for the wood. And I was wondering if there's any chance, since it's a limited warranty, that it could be recovered for more than just that.
Yeah, the warranty on it is, I assume there was a written warranty provided at the time of the purchase?
Yes, it's online, too, with the company that makes the Thompsonized wood is the name, but...
Mm-hmm. Yeah, you're probably limited by that warranty. Now, who put it down for you? I mean, don't give me a name, but was it a contractor?
Yeah, I had a contractor, a friend contractor that put it down for me, but the warranty does say they shall have no liabilities for installation or reinstallation, but it doesn't say about taking the old one off because, and the wood only lasted 5 years. I never saw a deck. It should last 20 years before you have any problems. And I was wondering if, because of that short time span, that it's really rotting and it's not supposed to. It has a limited lifetime warranty, and I just wondering if there's any recourse in that.
Yeah, you know what? The short answer is the warranty disclaimers make a problem. The long answer is sometimes you can walk around those things. Off the top of my head, I can't give you the answer. If you call in my office, Steve in there would be the guy who probably best qualified to help you figure out the answer to this. Unfortunately, that might end up costing you some money. But long and short of it is, it seems to me, and I'm just again thinking out loud here, that a warranty doesn't disclaim all liability, and so if it's so far inferior of a product, I'm not certain you might be able to walk around the warranty. But it sticks in my head that it seems to me that there's a lot of limited warranties in these construction materials, and that's why I want you to talk to Steve, because he would know more about that than me.
Yeah, because like I said, the cost to replace would probably be $5,000, and 5 years ago it was $2,400. But that was to put it on, not to take it off and put it on.
Right.
And the wood is really rotting badly, like there's something wrong with it. But the other
problem we've run into is the one time that I remember tangling around with this a little bit. The manufacturer right away was able to point to us how the guy who put it down wrong, and how that really created the problem. But it wasn't a rotting issue there. It was all right, man.
All right, then. Thanks a lot.
It's the best answer I can give on the top of my head. Alan, you're on the air.
Thank you, Carl. I have a real estate question. When a house goes up for public auction, what is the normal fee for an attorney who's going to handle that part of it? He's going to handle just doing the... Well, he'd be there for the auction and then, I guess, handle all the paperwork that's necessary. Yeah. Be a normal fee, I don't know, anywhere from a couple $100 to a couple $1,000. And why do I give you such a broad range? Is I just don't know everything that's going on with it. But I can't imagine that it would be particularly expensive, if that makes sense. Do you think 1% of the sales price is reasonable? Well, here's the answer. If it's a $500,000 house, then probably not. If it's a $100,000 house, it's probably right in the ballpark.
a percentage point too. I mean, there's some risk being shared there. If the auction's particularly low, the attorney's not going to make a lot of money. If the auction goes particularly well, the attorney makes more money. So I don't see it as it doesn't strike me as a bad idea.
Okay.
I don't know.
All right.
I mean,
All right.
I have in the past couple times over the years offered clients a contingency fee or an hourly fee. And I had one client say to me, well, can I pick after? I think I said this before on the air. And I really liked that because it made me laugh. But the answer is, yeah, and I see what you're, and I said, we'd all like to pick after, right? I'd like to do the same. I'm sure we'd both pick opposite, too. All right, my friend.
That. Thank you very much, and have a good day.
Okay, let's see. I got one more here. But just don't forget, we're going to be live next week, 1 to 3 in Lancaster, 1000 North Prince Street. We're going to be giving away some Rillo's gift certificates. We're going to be giving away other stuff. You come in person. You can ask your question live in person. You can get some food. You can meet Paul Chase, who's our realtor friend who's going to be there. He's a real estate divorce specialist. So if you're in the middle of a divorce, you don't need me as a lawyer. You already got lawyers, but you're trying to figure out how to sell your property in the middle of a divorce. He's the guy that can help you out. He'll be there. We'll have other realtors there to help you with real estate questions. John, you're on the air.
Yeah. I tried posting online to you here once. Question is, how may you obtain ownership of an abandoned travel trailer? Travel home is sitting on company property here now for over 2 years. The owner of it shows no interest in it, hasn't paid any of the settlement fees or anything else on it. And to sort of help the company and everything else, because we would like to get it out of there, I was going to see if I could somehow get ownership so we could get rid of it.
Yeah, usually what you need to do, if it's it's titled property, right?
Yeah.
So what
like
you could
a vehicle or a car. Yeah.
Yeah. So you can go to somebody with a salvage license. And they can salvage it. And with the person with the salvage license, they can actually reconstruct the title then after they salvaged it and sell it to somebody or scrap it or do whatever's appropriate with it. So you're looking for somebody with a salvage license. I'd call around to local tow truck companies to find somebody with a salvage license.
Okay.
All right.
All right. Thank you much.
All right. Good luck.
Yep. Bye.
Yeah, that's automobiles, things like that. Say you had one sitting on the parking lot for a year at your mall. You get the guy with the salvage license. He can come and get good title to it. He has to go through a process, which is basically notifying the potential owner of it, etc. Bill, you're on the air.
Hey, Carl, you're doing great. Every time I bought a house, there was always a question in my mind as to whether I should have an attorney there for me or not.
Yes, you should.
Okay.
Yes, you should. All right, man. Got to go.
Bye.
Live next week, 1 to 3 p.m. We're going to be 1000 North Prince Street in Lancaster. 1000 North Prince Street in Lancaster. Come on down. 1 to 3 from now on, too, by the way. And if you want to get hold of us, go to RomingerLaw.com or weekendappointment.com. I'll see you next week in Lancaster.